Hi, Omer.
Hi, Frank.
It's great to have you on today. Um, Again, I mean, I'm saying it's great, even though I'd rather not have you on, and I'd rather Gaza not being bombarded and genocided, obviously. But I guess we are at a time when a lot of people around the world are trying to think what they can do to stop this. Whatever you want to call it, madness, slaughter, genocide. The last 17 months of the first, I don't know, phase of this genocide were already incredibly hard for, obviously, for Palestinians first and for people fighting for justice in Palestine. I guess people had including obviously people in Gaza, a bit of a breather with the ceasefire between Hamas and Israel on January 15th. But it looks like the genocide started again on steroids on March 18th, with Israel killing like more than 1,000 people in a day. And so the question so many people are faced with is, what can we do to stop it? In terms of the countries, we had obviously South Africa going to the ICJ. We've got Karim Khan, the prosecutor of the International Criminal Court, issuing arrest warrants against Netanyahu and Gallant. You've got hundreds of thousands of people out in the streets pretty much every week protesting against this genocide. But you have chosen, in a way, I was going to say another route. It's not another route because it's a legal route, but it's quite a different one, and it's a very interesting one. So you're not prosecuting Israel for genocide, like in a way the ICJ case of South Africa, but you're prosecuting 8 people, Israeli leaders in some way or another in the media or in politics, for incitement to genocide. I was wondering if you could explain me why you've chosen this route.
Yeah, sure. I mean, I think to begin with, first I'm sharing the sentiment of the helplessness and, you know, in the past, since October 7th, it is twofold, no? I mean, one is the the inability of some people in terms of free speech and even academic freedom and all that, to say what they think. But I relate more to something more existential that I've personally felt also as an Israeli on October 7th, this loss of language and inability to describe the experience, that we don't have still and certainly not even the political imagination of what we are witnessing. On the one hand. On the other hand, it's we arrived where we went, in the sense that it's been decades that we are warning, or we being from the Israeli side, the radical left, non-Zionist, minuscule fraction that. So it was not surprising in this sense of decades of that we were going in the same direction that we were all were afraid of. Yeah, and what I did at this case is in to some extent a response to this guy. It was my personal therapy, if you wish. Like, the only thing I can do, I'm a lawyer, so I'm going to the court. If I was a plumber, maybe I would go to fix your toilet. This was my tool, and my students' tool, at my clinic, at a clinic that I'm co-directing with another international law professor at Sciences Po. Because for them too, you remember the demonstrations and everything that took place in the campuses. The administrations didn't provide any means for these students, be them Palestinians, be them pro-Palestinian, doesn't matter, to channel their in within the curriculum. I'm not saying now within, so like on the street. So that was kind of and the choice. I think we should first make distinction between the ICJ and the ICC, or more broadly between what we describe as state laws of state responsibility and individual criminal responsibility, so state non-criminal responsibility and individual criminal responsibility. And so my choice the route that I chose to take, again, following research and so on, was in part a conscious choice not to tackle the ICJ state responsibility genocide convention route, and to go for the individual responsibility for different reasons that I can elaborate. And secondly, not to go for genocide, but to go for what we qualify is independent crime that is called incitement to genocide. And in a minute, I will explain why it matters and what is the difference, and why it was for me more smart or solid way to move forward. Voila. So maybe to the ICJ I will get later, maybe when we talk about issues like intent, but in general, I would say that the case introduced three novel, interesting layers. The first is exactly that we show that, unlike what most people may think, the ICC doesn't have only 4 crimes under its jurisdiction, namely aggression, genocide, war crimes, and crimes against humanity, that the 5th crime of the ICC is incitement to genocide, something that we call an inchoate crime. Whereas many may mistakenly believe that incitement is what we call mode of liability. So you can commit no matter which crime, war crimes or crimes against humanity, and then we attach a certain level of liability if you are the principal perpetrator, or if you are aider and abettor, and so on. There is this hierarchy of responsibilities, no? And normally when we move to the more secondary levels of responsibility to convict someone, for example, for aiding and abetting a crime against humanity, you must, under the Rome Statute, the constitution of the ICC, you must prove the main crime. So if it's a crime against humanity of extermination, I cannot indict you or convict you for aiding and abetting a crime against humanity of extermination without showing that there was extermination. The only exception to this rule is incitement to genocide. So with incitement to genocide, I can establish that you incited others, publicly and directly called others to commit genocide, without having to prove the main crime, in this case, genocide. And this is an exception that applies only to incitement and only to genocide. So only to incitement to that. So incitement to a crime against humanity is not criminalized at all in the Rome Statute. So you can incite to a crime against humanity of extermination, no one will punish you. So it is a very sui generis crime, and the question is why the drafters of the Rome Statute exceptionalized incitement as opposed to ordering a crime or soliciting a crime and so on, and why they limited it only to genocide. And the understanding is, by the way, it's not particular to the Rome Statute. You find the same in the Genocide Convention, in the ICTR, the tribunals that preceded the International Criminal Court. And the reason is that the understanding that if you want to prevent a genocide, or if you want to terminate as soon as possible a genocide that is unfolding, you have to suppress the incitement phase that always accompanies such a complex crime, multi-actor, many people needs to commit it in concert. And so there is always an incitement phase that either precedes or accompanies the first stages of in the making genocide. And this understanding that the preventive purpose, the harm of incitement to genocide, you don't kill anyone by inciting someone, but the harm is the risk of creating a genocide. So this is what the normative rationale behind underlying this inchoate, independent crime. And for us, it was a solid way because, everyone is aware of the controversy whether it is a genocide or it's not a genocide, it's a genocide plus or a genocide minus or only crime against humanity of extermination. For us lawyers, the question is even more difficult because the question is whether you can prove, even if I believe or you believe that there is a genocide, it's a different question if I can prove that, given the elements of the crime and so on. And this is in part, if you ask me also, why the prosecutor was not was reluctant to include this kind to go, because prosecutors always try to choose this. Maybe he doesn't believe it is a genocide. I don't know. I mean, we are not in touch, but to the extent that a lawyer thinks it's a genocide, it's maybe this lawyer would think that it or prosecutor especially that it can be proven, especially when it's ongoing, the armed conflict, especially when you don't have boots on the ground, especially, etc., in terms of the evidence gathering and so on. So I didn't want also to enter this controversy, and I thought that the one genocidal act, namely incitement, not a single decent person would dispute that it was that the crime has been committed. You know, another advantage of this, because again we are dealing with public state. It's a speech crime, right? So we are dealing with public statements that are in the public sphere, mediatized, cannot be accessible to everyone, and therefore also in terms of other excuses for non-prosecution is there is no need to gather additional. You don't need victims even. It's enough that
Yeah, I wanted to ask specifically about this. So what you're saying is that incitement in itself, let's say someone says we should kill this whole group on TV, even if the group is never killed or never harmed, this is a crime anyway, right?
exactly under the Roma, it's a standalone, it's independent crime, irrespective of the principle. So yeah, yeah, that's exactly how it is.
Okay.
And this is why, on the one, and maybe we'll get to it later, but on the one hand, I'm avoiding all this difficulty of, again, what is unfolding on the ground. I don't need the victims, and I don't need all the atrocities that are taking place to prove that they are under this framework or not. And again, one purpose is accountability and and justice and retribution, but also because we are dealing with an ongoing situation, the urgency is prevention. And that's why also this is like the paradigmatic crime where you say we have to prosecute incitement if we want to terminate or prevent a genocide. And again, there no resources involved, no, and whether the prosecutor can enter. There are no excuses for not prosecuting. It's not in dispute. If you read the brief and you see what people like Giora Island, of course, Netanyahu with the Amalek, Gallant with the human animals, Katz with the no drop of water until they leave the earth, and so on. But even more interestingly, and of course Herzog, with there are no non-involved or innocent and so on. But Island, when they say to starve, to create a humanitarian crisis, not to fail to prevent one or not to provide humanitarian aid, to intentionally starve the people and kill those who are not living a certain area, and so on and so on. It's really textbook for incitement to genocide. So this is the one layer. For the first time at the ICC, we show that we file an incitement to genocide case that is very, very solid, and again, factually and legally, we show how it is accepted as an independent crime. And then this was the first layer. The second layer, it was enough what we did. What this first layer is enough in terms of the doctrine of the ICC. It's international criminal law is a standalone body of law, independent. You don't need anything else. But we wanted to corner this prosecutor and to push and to show that there is no other choice but to prosecute this crime. And The second layer that we analyzed was we looked at the ICJ, we looked at the court across the street, and we analyzed that the findings of the decision in January 2024, when they said, look, it's what the standard there being plausibility, so it's plausible that the targeted population is exposed to a risk of genocidal act, and we kind of translated it to the similar, it's two courts, two subjects of these laws, states and state agents or individuals, and two different languages, but they adjudicate in parallel often the same matter that is won in the real world. And it's not the first time, you have Ukraine, Russia, you have Serbia, Bosnia, you have Myanmar, the ICC and the ICJ. You can find similar examples to that phenomenon of simultaneous proceedings ongoing when the conflict is also in parallel ongoing. No? And we looked at the other court, and our argument was that, first, plausibility under the ICJ translates to a standard, evidentiary standard that is called the ICC reasonable grounds to believe, which is the requisite standard to open an investigation, in our case, to extend an existing investigation, because Palestine is already under investigation, and to, if necessary, to request and issue arrest warrants. And we show that in the jurisprudence and legally, and that was kind of to say to the prosecutor, look, your point of departure is not from the ground, but from already you have the evidentiary standard established for you by the court across the street. So just to be precise, the argument is not that we ask the prosecutor to look on the evidence that South Africa generated. No, we say the decision on plausibility is in itself an evidentiary value for the ICC prosecutor. And then lastly, the third layer that we kind of, I'm sure by now you are aware of the principle of complementarity, which means that the ICC cannot operate unless the national jurisdiction is first conducting investigation on the same conduct and on the same crime against the same suspect, and second, that it is not unwilling or unable to do so. Unable, for example, Palestine could have jurisdiction over the situation in Palestine. Actually, it should have been the first place to go to, but they reported to the ICC. They said our judiciary is unable or unwilling, which is more the case of Israel, where they have a judiciary that is functioning, but they apparently may be unwilling to conduct this investigation. And so this is an ICC principle. So we had, again, with this first layer showing that factually the incitement of genocide has been committed, and legally that it's independent crime that they should and must prosecute and punish. It was enough for us to show the complementarity. But in between, we have the decision of the ICJ that, based on the plausibility finding, they issued 6 provisional measures, right? The third one being an order to the Israeli government to prosecute and punish the inciter. In their decisions, they cite 3 out of the 8 suspects that we identified in the ICJ decision of January 2024. And one of the 6 measures was go to the Israeli government, very clear, not ambiguous, as other provisional measures on humanitarian aid to the extent possible, all measures in your, like this kind of language which is open for interpretation. Here, no, it was very prosecute and punish the inciter. And by the way, Aaron Barak, the former Chief Justice of the Israeli Supreme Court, sitting in the ICJ as an ad hoc judge for Israel, nominated by Netanyahu, he joined 2 out of the 6 measures. One of them was incitement to genocide. And so first, what we understand from that the Israeli, maybe the most prominent legal scholar and judge, believes that it's plausible, because absent plausibility, they cannot order the provisional measures. So he acknowledges that it's plausible what is happening in Gaza. And secondly, that he also orders the government, if you order to prosecute inciters, it means that there is incitement, right? We cannot invent them out of the blue. So we waited until November 2024, 10 months. And at that point, the Attorney General and the legal advisor to the government, they notified the Israeli Supreme Court in domestic proceedings that because after the ICJ decision, Israel kind of did at least created a false impression or a facade of we are doing something. Because in the ICJ, they acknowledge the jurisdiction, they participate in the proceedings and so on. And so they were doing not criminal investigations as the ICJ order, but examination, which is a normatively non-existent anymore in Israeli law, but like some preliminary phase that they invented, and not for incitement to genocide under the Israeli genocide law, which exists, by the way, but incitement to ordinary penal code incitements, like incitement to violence or incitement to racism or incitement to terrorism under the terrorism law, not genocide, but still against the same more or less individuals, because you have inciters. I think it's too noisy, man. Inciters you can find by the thousands. If you open TV every night in Israel, you will find every night someone inciting, saying no women, no babies, no children, we should kill everyone, and so on. So it was not sufficient what they did, but in any event, in November 2024, they notified the Israeli Supreme Court. They say, we decided not to open a single criminal investigation or incitement to genocide. So for me, it was the cue to move forward. So there is no excuse for the prosecutor saying, let's give them time, let's see, etc. And actually the argument here, because complementarity, again, I didn't need the ICJ, but the argument here is, look, the ICJ order was directed to the Israeli government. Now that they failed and they breached the ICJ order, now it's redirected to you. So insofar as you don't prosecute it, you are breaching the ICJ order to punish and prosecute incitement to genocide, And I remind you the pre-trial chamber statement when they issued the arrest warrants, saying two things that are interesting. First, that Netanyahu and Gallant, but of course it applies to more than these two individuals, created living conditions calculated to bring about the partial destruction of the group. This is word by word one of the genocidal acts, creating living conditions, of the crime of genocide, not incitement to genocide, So this is a strong signal to the prosecutor. Secondly, that conduct based on which the arrest warrant were issued is ongoing. So this is ongoing, and therefore the duty of the prosecutor is not only, again, to hold to account past crimes. He is under the obligation to prevent future crimes. And the risk, as you just, when we started the conversation you just mentioned, is extremely high if you see the resumption of hostilities in Gaza, and what is going in parallel. To some extent, some will argue that Gaza is a destruction, but also destruction from the West Bank and elsewhere. So the risk is not being mitigated by no means by the ceasefire and so on, because the mines, again, maybe just to conclude, incitement means two things. One is the process through which the targeted population is dehumanized. And this, I think, again, which I don't need to put a lot of effort in the past year and a half, the statements and the conducts on the ground evidence this dehumanization of the population. And second, it requires normalization of the atrocities, allegedly genocidal acts or other international crimes, because when you incite someone to genocide, even if you will say it's not a genocide, he can pick up the message, or she, and commit a war crime or a crime against humanity. Not necessarily that they will follow exactly the genocidal acts, but in any event, yeah, I mean, the dehumanization and the normalization, because you need not only the actual, extreme right-wing fundamentalist messianic militias that infiltrated the IDF and now are doing whatever they want on their ground with no chain of command, but you need the general population to be at least indifferent to what is going on. And this is the enablers in every genocide. So again, irrespective of whether we qualify it as a genocide or not, I'm not entering this discussion. But incitement to genocide is not non-questionable. I don't know any single lawyer that will dispute that, and therefore I see no reason, other political, real politics, to prosecute and punish.
Thanks, Omer. I mean, you've answered most of my questions, but I still have a few. The resumption of hostilities in Gaza over the last few weeks have started again with more incitement, more open, blatant incitement to genocide. Like, for example, Israel Minister of Defense, Israel Katz, recently made like a public statement on Twitter and all over saying, return the hostages, remove Hamas. The alternative is total destruction. I guess this is also a very strong incitement to genocide, right?
Yeah, all these statements alone and certainly taken together, because Katz, when he was, I think he was the energy minister at the time, he said not a drop of water, not electricity, not until they leave the earth. I think they leave the place or something like which he meant like until they die. So this like dilemma of either forced transfer and deportation or death. This is by starvation or passively by starvation and humanitarian conditions, or actual killing. Is really ongoing on TV, prime time. All the babies, all the women, the babies will grow up to be terrorists. The women will give birth to, and also, and this is why also this discourse on law on sometimes I think you can commit these atrocities while complying with all the provisions of international humanitarian law on armed conflict, because and this is why I refuse the discourse of like what is military necessity and objective, and if it's a military objective, what is the proportionality, how many people, 400 to kill one combatant or one. All this discourse is irrelevant once you blur the distinction between combatants and civilians, and you see it in the statements that we cite. You see that it is, for example, if you look at in Yechezkeli, so who is Hamas? First, Hamas is a political entity and a military entity and a terror, but when you once you start to define combatants as including Hamas teachers, Hamas doctors, Hamas journalists, Hamas, and then what is the point of discussing what is military and civilians and civil objectives? All this instrumentalization of the laws of armed conflict is quite astonishing, and what you just said about the ongoing incitement. And again, the minds of the people are ready now. Just it's a question of the right opportunity to materialize this state of mind, no? And this is a huge risk, and this is another angle of our case, and which I think the prosecutor must pick up, given the risk, which is, okay, we can have this discussion on intent, but if you prosecute incitement to genocide, what is intent? Intent, it's either you find, like the Third Reich, you find in a drawer a final solution a manual saying this is the plan, and like something like this smoking gun. Some can say it's, there is the general's plan of Island, there is the decisive plan of Smotrich for many years ago that quite outlining something like that. Trump echoes these elements of this stuff. But absent that, let's say we don't have this kind of a smoking gun. It's either the pattern of conduct on the ground, which is, I think, what Amnesty and others tried to show in order to infer intent, from the conduct, or the statements. And the statements, again, it's from the mouth of the donkey. You cannot. They speak for themselves, and they are not in dispute, and they are just getting worse over time. So, and yeah, and this is why also, the ICC, when we talk about intent, we talk about at the ICC, we talk about human intent. So it's because the person said this and that, I can infer the human intent, which may be even lower than the intent of the ICJ. Because the ICJ, the difficulty is that what is an intent of a state? You see, it's the accumulation of all the leaders or the entire. How can you, qualify what is it's an abstract entity. It's not a human entity, and therefore already linguistically it's difficult from legal perspective to decipher, to unpack this, and then let's say there is intent, and let's say that one state is condemned for genocide. What is the sanction? I mean, symbolically, it's a lot, but and it's irreversible, and it's But I think that there is reason why people think that in the past the ICJ already found someone responsible for genocide, and this is not true. To date, the ICJ has never condemned a state for committing genocide. Some will tell you, or you will tell me, Serbia for Srebrenica. But it's not the case. They were found responsible for not preventing others, by the way, the prosecutor duty to prevent, from others, non-state actors that committed Srebrenica, So the convention sets a high threshold. The jurisprudence of the ICJ in Serbia, in Croatia, in other, or even raised the threshold, this only one possible explanation and all that. And therefore, it's a huge, endeavor. Me, on October 7th, when before one shot was shot from the Israeli side, just witnessing the atrocities of October 7th, I thought that there is a risk for genocide, which is enough as a retaliation, which is enough for the provisional measure. That's what you need to substantiate. So I was thinking, immediately I was thinking, ICJ, someone must go. They will lose on the merits, because I didn't know how it will. I never imagined 1 year and a half of what we are witnessing, but I thought for the risk, it's enough. Like they will lose on the merits, but it's worthwhile to go and to lose in the end, but to win the thinking that maybe the West will contain Israel and restrain it based on such a provisional measure, for example. But also in Yugoslavia, the same. The ICJ, they issued a provisional measure saying don't do genocide, and then the Srebrenica happened afterwards. So that's why, just to explain why I want the ICC less than for the ICJ.
I wanted to end with exactly this question. You talked about, the Serbs, don't do genocide, then Srebrenica happened. People, like non-legal people, so most people, will tell you, Omer, it's great. I mean, we've got the arrest warrants, the ICC, we've got the ICJ. We've never had a decision like this from the ICJ when it comes to Israel. I mean, we had one in 2004, but it wasn't as thorough and as binding and as important in a way as this one. We've got people all around the world trying to do like individual prosecution for soldiers, for binationals, etc. So the law is on our side. But regardless of all this, we've got your case for incitement, but regardless of all this, on the ground, nothing happens. And we are at a time where the US, Trump, Netanyahu are completely destroying the international rules-based order. What would you say to these people? Like, do they still need to have faith, at least a little bit, in the international justice system?
No. And it's so we are living in times, Israel is if there is something more dangerous than a powerful state, is a powerful state that experiences itself as weak. And if there is subjectively as weak, as a victim, and this is, I mean, again, I'm Israeli. I mean, the pain and the post-trauma, and I have, I'm affiliated with both sides, so I've friends that lost people on both sides, and I think that this subjective, the victimizer that experience itself as a victim, the beaten child that grew up to be a beating father, it's all these cliches. So this is objectively became super dangerous on October 7, when objectively it was maybe the weakest moment of Israel. And the shame and the guilt of the security apparatus and the sentiment of revenge, the human sentiment of revenge, shared across the political board to date. There is no, political dispute on Gaza. It's a consensus, and all that instrumentalized by the most extreme right fundamentalist like Hamas, like Islamic Jihad. I mean, in terms of the ideological drive behind government, is a danger not only to the Palestinians, because the dehumanization doesn't stop after decades of occupation and apartheid and all that. Everything infiltrated inside Israel, inside the 67, the 48, the 67. And you see it with the hostages also. No one imagined that Israel will be willing to sacrifice a single Israeli Jewish soldier, but certainly let alone citizen. And now they are like, they always favors to celebrate death than to secure their own. I'm talking, okay, the genocide, like as Ehud Barak said once, if you remember, if I was born on the other, as a Palestinian, I would be a Hamas or Islamic Jihad militant, no? So this, they understand the other side, and they don't care about the extermination of the other side, but their own. This is really a signal that of how dangerous, where we are, and I'm saying all that to say that it's not only about the fate of Palestinians, or not even the fate of Israelis. It has an impact on the Jewish communities all over the diaspora that are now at risk, and it's not even, it's about, not even about this. It's not limited to this conflict even. It's because what is international law? I will end with your question, because the international law there is no enforcement mechanism, as you saw. The ICJ, the ICC is very politicized and weak, and it's only built on state practice. And if we accept what is going on, and we do not use all these very frustrating and unhelpful legal means, that will become the law, what is going on. The conduct, the hostilities in Gaza, in other conflicts elsewhere that are taking place now and will take place in the future, that will become the lex lata. Because international law, customary law, is about what the professor says in the university and what the states are doing on the ground. This is what international law is. We have no police or anything, right? And if we accept that, we will see it elsewhere. That will become the standard, of like, we are now scorched earth policy. We are not fighting. We are just destroying all this, everything, that will become the standard in other conflicts. And this is why it's not because I believe in international law. It's just because if we won't do that, the consequences are much far, and I agree with all the critics. We are now living in time of collapse of the international legal order as we know it since Nuremberg, more or less, and nothing with Trump and Musk and all that. So we it's not that we are winning. It's not that I'm hopeful or I believe in international law. It's just that, I mean, it's we can't do otherwise.
Thank you, Omer. This was very enlightening and interesting. And I think, as you were saying, we have to. The only thing we can do is not stop. So we have to try, any means we have as a lawyer, as an activist, as a filmmaker, to stop this. Because also, as you said, if this becomes the norm, we are all in danger. And I guess a human being, emotionally and spiritually, will always say, it's like on survival mode, this is not happening to me, so I'm okay. But it's getting closer and closer. So I think we all have a duty to act. So thank you, Omer. Thanks.
Thank you, Frank.